Court is going on the record in 2022 CR 4751, State of Texas versus Kenneth Williams. Mr. Churek, are you ready to proceed?
I am, Your Honor.
All right, this hearing is scheduled at 9 a.m. It is 9:01. And I see that the state is not here.
Not really.
All right, state, do you have your witnesses?
Yes, sir.
All right, where is the witness?
Okay, now.
Is your witness in the courthouse?
Yes, Judge.
Okay.
In the waiting room. Judge, would you like me to read the enhancement right up now?
Let's wait and see if your witness is here.
The witness that we're calling first is on another case that we're putting up.
Okay.
Yes.
And have you discussed with Mr. Churek whether or not his client is going to plead true or not to the enhancement? Or no?
We haven't discussed that yet. Here, I got a switch.
Yes. So, Mr. Churek, is he? going-
Yeah, he said that's completely true.
All right.
Hold on,
Yes.
am I allowed to elaborate about it?
Your attorney is allowed to present whatever evidence he wishes to present.
Okay, thank you.
So is there going to be a plea of true or no? Is there going to be a plea of true or no?
Yeah, there'll be a plea of true.
All right.
Yeah, it's correct, right? The enhancement.
Yeah, not be necessary, but just in case.
Okay. All right, are both parties ready to proceed, state,
Yes, Your Honor.
defense?
Yes, ma'am.
All right, state. Do you wish to read the enhancement?
Yes, Judge. repeat offender enhancement allegation, and it is further presented in and to said court that before the commission of the alleged above, of the offense alleged above on the 19th day of December AD 1997 in cause number 1997 CR 0279 in Bexar County, Texas, the defendant was convicted of the felony of murder.
All right, how do you plead to that, true or not true?
True.
All right, state, is there opening statements,
And we'll wait, open, Judge.
defense?
Wait, Judge.
All right, state, call your first witness.
State call.
Sorry, Judge, we would ask that the court take judicial notice of the evidence that was presented in guilty innocence.
All right, so noted. Any objections other than previous objections?
No, Your Honor.
All right. State, call your first witness.
State House Detective Trevino.
All right, could you raise your right hand for me? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record, please.
Detective Gregory Trevino.
That's.
Detective Trevino, how are you presently employed?
I have about 8 years of service and currently I'm assigned to the narcotics unit as a plainclothes detective.
And is that with San Antonio Police Department?
Yes,
And were you on duty on August 25th of 2019?
yes, and at the time I was employed with the street crimes unit for the San Antonio Police Department in a uniform officer capacity.
And being on the street crimes unit, can you tell us a little bit about what that entails?
We were assigned areas of town and basically we go there, we would be assigned there because there would be issues with crime. So we go make apprehensions for either, narcotics trafficking or any violent crimes, robberies, or vehicle theft, or things of that nature.
And on August 25th of 2019, were you alone or did you have a partner?
I had a partner.
At some point on August 25th of 2019, did you come into contact with Kenneth Williams?
Kenneth, I don't recall that name, but I have several other names of defendants that provided to me.
And what name was provided?
Due to the report, there was a Germany Williams spelled several different ways.
Judge, I'm gonna object to him reading from his report.
Sustained.
Detective Trevino, did you create a report in response to this incident?
I did, yes.
And would seeing a copy of your report refresh your memory?
Yes.
Your Honor, may I approach?
Yes.
No, 74.
I'm going to mark your report as State's Exhibit 74. Just use it to refresh your memory, but please don't read from it, okay? Okay, Detective Trevino, what was the name of the person that you came in contact with?
Germany Williams.
And how did you come into contact with him?
We initiated a traffic stop. The vehicle he was operating was about a year old. Registration was about a year old.
And Detective Trevino, when do you know when the registration was expired? Do you know the date?
I can't recall the exact date, but it was a year prior to contact with the defendant.
And how do you guys usually confirm that?
Usually with our computers that we have on our patrol vehicles, we'll run the license plate and it'll tell us. And then also there will be a sticker that will verify on the physical sticker on the vehicle.
And is that why you initiated a stop for Germanic Williams?
Yes.
Okay. And after you initiated the stop, what did you do after that?
We tried to make contact with the defendant, but he parked pretty quickly and then tried to distance himself from the vehicle.
Okay. So after he started walking away from his vehicle, were you able to contact him?
Yes.
And what did you do then?
We contacted him, detained him, just the fact that he was distancing himself from the vehicle, he was kind of making furtive movements, walking away from us. We, at the time, we had a marked patrol vehicle with lights, and I don't recall if we hit the siren, but typically we'll do that for people not wanting to make contact with us or initiating a traffic stop. So at that point, he was detained.
And is that standard procedure for SAPD?
It not only is it standard procedure, it's kind of an officer safety concern as well.
And after you detained him, did he provide you his name?
He provided me a version of the name, yes.
And when you say a version, what do you mean?
It was just a different spelling, different date of birth.
Were you able to find him in the system?
Not immediately.
When were you able to find him in the system?
It took me several tries and then several times going back to speak with him and then trying to get him to clarify his date of birth and the spelling of his name.
So was that information that you were given, was that provided by Mr. Williams?
The correct information was provided after a number of attempts to get that from him.
But he also provided you false information.
Yes.
Okay. So after you were able to locate him in the system, what did you do after that?
So after that, it was, he failed ID to someone he knew was a peace officer on duty. And then at that point, he was arrested for failed ID, false or fictitious info. And then from there, we went to search the vehicle.
And did you find anything when you searched the vehicle?
Immediately when I opened the door, there was a bag of alleged narcotics.
And sorry, detective, why were you searching the vehicle?
He was just a person under arrest due to the fact that he tried to distance himself from the vehicle. On top of that, typically we will tow a vehicle, because at that point he was under arrest. Typically when we tow a vehicle, we do have the authority to inventory what's in there as well. I mean, I didn't even get to that point because immediately when I opened the door, which if he would have been in his vehicle when we stopped him, I would have opened the door away. So that would have been, it doesn't blame me once I opened the door.
And what did you find in the driver's door?
It was a bag of alleged narcotics.
And what did you do after you found the narcotics?
At that point, we recovered it, and then later on in the process, we field tested it, which field tested positive for the presence of cocaine.
And do you remember where you pulled him over? Was it an address or the intersection?
I don't recall the address, but maybe a street name, Lockhart.
Okay, and you can refer to your report if that helps. Do you know where you pulled him over?
Yeah, Lockhart, I don't know the block number or anything, but.
And is that here in Bear County, Texas?
Yes, it is.
And as far as the person that you arrested, Germanic Williams, do you see him in the courtroom today?
Yes.
Can you point to him and identify him by an item of clothing?
Defendant's wearing a black long sleeve shirt.
You want to make the record reflect who's identified the defendant? Just a second, Judge. Detective, did the defendant make any comments about his vehicle?
Well, initially said it was not his.
And did that change?
Toward the end, he said it was his after the fact, after you got his correct name, so.
He said that the vehicle was his.
It's at the end of the investigation.
We'll pass the witness.
Right, defense.
You have your program video on all times during the stop.
Really, so it's
And that program video not only showed the outside, what was going on, but also had in the cab of the vehicle. Is that correct?
in the rear seat, sir.
Right. So you can see actually what was going on in the dash of the vehicle. Is that correct?
Of the dash of the defense vehicle,
No, your vehicle.
it leads out the front and we have a camera in the rear.
It can see the computer, right?
I don't believe so, no, sir.
All right, we got a video. And we can play that video and think real hard. Isn't it a fact, sir, that you did not run the license plate of that vehicle until you made 2 U-turns, followed the vehicle, found it, and then looked at the computer once you were stopped, ran the license plate, and then hit your lights? After,
I don't recall that, sir.
you don't recall that? We can look at the video of that.
Okay,
All right, Judge, how do we play a video?
All right, if you would like for him to review the video,
I can do that. We can play the video for him to look.
all right. State, has your witness had a chance to review the video?
Is this, which?
This is the video of the stop where they run the license plate after they stopped him, not before.
Can you specify, is it the body cam or dash cam?
It's the dash cam in the vehicle.
All right, so this is what we'll do. Mr. Churek, if you could please have that marked. And state if you'll have your witness have a chance to view defense's exhibit. What number will that be, Mr. Churek?
This would be number 1.
All right,
And I've got, unfortunately, it's got a number of videos on it.
all right, so we'll have your witness have a chance to review that, and then Mr. Churek can ask your questions.
Okay.
So if the witness, if you could step down, the way to view it will be on the computers at that desk, Mr. Churek.
Judge, I apologize for not having thing. My law clerk, an assistant graduate of law school, walked in the office and advised me that she was quitting because she needed to study for the bar.
Oh, well, good luck to her and her bar exam.
So she's left me shorthanded and
Oh, that's okay. Oh, just 1 second. Can you approach? So we really don't need the camera. It's just for me to be able to see the videos instead of looking back here.
Yeah.
But when you get ready to do the sound on the video, if you're doing a sound, just
Turn it
remember to
off.
click the sound at the bottom. All right, thank you.
Yes, sir. Let me get the link sent to that.
Okay, and I'll give you the number if you just need, do you just need the number?
No, that's it.
Oh, are you ready to proceed?
Yes.
All right, if you'll take the witness stand, please. All right, just one moment. Brent, are you ready?
I'm ready.
All right, defense.
Mr. Trevino, you saw the video. You made one U-turn in that video looking for Mr. Williams' vehicle, did you not?
I couldn't tell from that angle, but we ran the vehicle first before initiating the stop.
Right before you initiate the stop, you ran the vehicle. After you made one U-turn, you actually pulled down another road. Is that not correct? Saw a vehicle, was not the vehicle. You then made a U-turn, backed up, turned around, and came back the other way looking for his vehicle. Is that correct?
We were looking for the vehicle, that's correct.
Right. And at that point, did you not run his license plate after searching for his vehicle?
We did, and then we stopped it.
Okay, so in fact, you were looking for the vehicle before you ran the license plate, because that's what the video showed.
So it's common for my line of work for people to avoid us. So, at that point, we'll start investigating it a little bit more when people are trying to intentionally get out of our way. So then we ran the vehicle and then we initiated the stop.
Intentionally get out of your way.
Yes, sir.
So what does that mean, intentionally get out of your way?
That means we're behind them in a big old car with, lights and things that are, say 911 on there. And then them going another way from us immediately so they can try to avoid us.
So every time you come behind a vehicle and it makes a right turn, they're avoiding you?
A regular right turn is different from multiple turns, yes, sir.
Multiple turns.
Yes, sir.
Officer Trevino, you had absolutely no probable cause for that stop. You were searching for that vehicle, is that not correct?
We had 100% probable cause, which was expired registration.
After the fact, you were searching for that vehicle without probable cause.
But we still initiated the traffic stop after the probable cause, sir, so there's no issues with that.
You don't, you in fact, once again, made a U-turn searching for this vehicle and ran that license plate only after finding that vehicle. Is that correct?
Objection, Your Honor, asked to answer the argument.
That'll be overruled. You can answer the question.
Yeah, so we were searching for the vehicle. ran the plate, sir, and
I
then
have no
we
further
stopped it.
questions. That's the witness.
Detective Trevino, what brought your attention to that vehicle?
Again, as I was trying to explain, typically a regular turn, hey, I'm going around a regular turn, that's a little different than multiple turns. Maybe we can see in there, the guy's looking at us nervously. That's, to me, that's evasive. So then that catches my attention. So, hey, what's going on here? So then we run the license plate and we initiate the traffic stop.
Nothing further, Your Honor.
Trevino, it was dark out, right?
Sir?
It was dark out?
Yes, sir.
Okay. And so you have a hat, I passed the witness. No, one more question. You were in an unmarked vehicle, is that correct?
I don't recall. No, sir.
Yeah, you were in an unmarked vehicle. You go and often drive in unmarked vehicles, is that not correct?
At the time, sir, yes, sir.
All right, pass the witness.
State.
Detective Trevino, are you the one who put the narcotics in the property room?
I believe so.
Nothing further, Your Honor.
All right, any
No
further questions? All right, is this witness excused?
Yes, ma'am.
All right, you're excused. State, call your next witness.
And Your Honor, I apologize. We have one other question that we need to ask Detective Trevino.
All right, Detective Trevino, they're asking that you come back to the witness stand. All right, and you're still under oath, state.
Detective Trevino, was there a case number assigned to this?
Yes, sir.
What was that case number?
Can I refer to our report for that? SAP 19182377.
Okay, Judge, nothing
All right, you're excused. State, call your next witness.
State Post Danielle Moye.
All right, can you raise your right hand for me, please? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God.
Yes, ma'am.
All right, you can lower your hand if you can state your name for the record, please.
Danielle Moy, last name is spelled Moye.
All right, state.
Danielle, how are you currently employed?
I work at the Bear County Crime Lab as a forensic scientist.
And how long have you been employed there?
I have been working with Bear County since May of 2020, so around 2 years.
And what is your educational background?
Starting a little bit. I have my undergraduate, my bachelor's degree in chemistry from Virginia State University, and I have a master's of forensic science from George Mason University.
And do you have any training that qualifies you as a chemist to work at Bear County Criminal Investigation Laboratory?
Yes, when I first got hired, we go through about approximately 3 months of training of overseeing other people with the evidence and then being released to do surprise casework and then being released. And I also have a license with the Texas Commissioners.
And what are your duties at the laboratory?
To analyze evidence.
And have you testified before as an expert witness?
Yes, ma'am.
On few or many occasions?
I have tested around 3 times. Once in Wilson County and the other in Bear County.
And does the Bear County Criminal Investigation Laboratory have any credentials or certifications?
Yes, we are an accredited lab.
Is it possible to take an unknown substance and identify it?
Yes, ma'am.
And can you tell us how that's done?
You do a series of presumptive analysis as well as confirmatory analysis.
Your Honor, may I approach?
Yes.
And then what's been marked as State's Exhibit 75. If you could tell me if you recognize it.
Yes, I recognize it as the report that I generated.
Okay. And sorry, you said it is the report that you generated?
Yes, ma'am.
And when was the evidence received? No, that's fine.
The evidence was received into Bear County Crime Lab, March 23rd, 2022.
Okay. And what happens when the evidence is received by the lab?
When the agency comes to drop off the evidence, it goes to our evidence receiving department. And evidence receiving and analysts down there will take the evidence into their custody, into the lab's custody, and place it in the vault. Afterwards, the submission form is then sent to my department is drug identification. And when I grab those submission forms that coincide with the different pieces of evidence, I go downstairs to pick it up from the evidence receiving team. Once I do that, they then transfer the custody into my custody, and then I have custody until the case is completed and sit back downstairs.
And what do you do with it once it's in your custody?
I assign it to myself within our internal chain of custody system. And then once I assign it to myself, I will place it into the drug identification vault until I'm ready to open the evidence and analyze the evidence.
And are you the one that analyzed this evidence?
Yes, ma'am.
Okay. And how do you recognize State Exhibit 75 from any of the other from the other forms that you have generated? Is there a number assigned to it?
Yes, I recognize the criminal investigation lab number, also called the CIL number.
Okay. And what is that CIL number?
The CIL number for this case is 19-06372.
Okay. And does that also have an SAPD case number assigned to it as well?
Yes, ma'am.
And what is that case number?
The SAPD case number is 191823777.
And do you also have a suspect's name on your form as well?
Yes, ma'am.
And what's that name?
The suspect name is Jermaine D. Williams.
Can you spell his first name for us?
I can. It's JERMANIE.
Now, did you conduct the presumptive test on the narcotics?
Yes, ma'am.
And what is the purpose of the presumptive test?
The presumptive test is conducted in order to give me the steps that I need to take forward.
And what steps in the presumptive test tell you to take?
So in this case, I performed 4 separate presumptive tests. Did you want me to explain that?
Yes, please.
Okay, the first test that I did was a color test. The reagent that I used was a cobalt-cyanide. And what you do is you get an empty spot plate, you place the cobalt-cyanide in the well to make sure that there's no color change. This gives you your blank. And then you take a small amount of the evidence that was in the case and you place it in the same well. In this case, it was indicative of cocaine in terms of blue color.
And what do you do after the presumptive tests are complete?
All of them?
Yes.
Once the presumptive tests are complete, then that's how it's when we do the confirmatory test.
Okay. Is that what you do next to this?
After all of the presumptive tests?
Yes.
I'm sorry, because I did 4 of the presumptive tests. So yes, after all of the 4 tests, I completed the confirmatory test.
And what's involved in the confirmatory test?
The confirmatory test is the gas chromatography mass spectrometry, also known as GCMS. Would you like me to explain that?
Yes, please.
Okay, the GCMS, you take the sample and it's injected into the instrument. It's a separation technique, sorry. So with the separation technique, you take the sample and you inject it into the instrument. Inside of the instrument, it is heated into a vapor, and this vapor then travels inside the column, which is located in the instrument's oven. Once it travels to the column, it is fragmented into its different components. I'm sorry, not fragmented. It's separated into its different components as it comes off the column. These components are then sent to the mass spectrometer to be detected. So these components are then hit with a beam of electrons and fragmented, and these fragmented ions are analyzed and detected.
And does that give you a conclusion at the end of the confirmatory test?
Yes, so the fragmented ions that were detected, they will produce a spectrum, and this spectrum of ions is then compared to a known spectrum from our laboratory library, and then the unknown is compared to the known, and then the decision is made.
And what decision was made in this test?
And this test, it was, the decision was that it was cocaine.
And after you finish your presumptive and your confirmatory test, what do you do with the evidence when you're done testing it?
Once I'm done testing the evidence, I seal it back up, and then I release the case. Like the report is generated and I release the case, and the evidence is sent back out, the evidence receiving.
And Do you weigh the evidence?
Yes, that's the first thing I do. Once I get the evidence and I start to sample, before opening the evidence, I will make sure that everything on the outside container matches the submission form. That's the CIO number, the agency number, the suspect name, the alleged substance that's inside of it as well. And then I weigh it before I do anything else.
And what was your, what were the resulting conclusions of all of your testing at the end of this?
That, the final result,
Yes,
the final result was cocaine-free alkaloid.
and what was the weight of that?
The weight was 4.598 grams.
And is cocaine a controlled substance?
Yes, ma'am.
Or past witness?
Good morning, Ms. Moore.
Good morning.
What protocols are in place in your office to ensure that quality control is made on each test?
I'm not sure I understand what you're asking.
Okay, well, you have protocols in place, do you not, to assure that the testing is done properly, right?
Yes,
What are those protocols?
so we have SOPs that we go back to, and those are our standard operating procedures and tell us what to do. I also keep a very clean bench to reduce the chance for contamination. I also only open one case at a time, so there's only one case open on my sampling desk, while the other cases are differently, or someplace different away from it. And then we make sure that everything is calibrated up to date, the instrument is working fine.
Okay, how often is your GCMS inspected and maintained?
We maintain it as needed, and the preventative maintenance is done once a year.
And who is responsible for that maintenance?
The entire lab, the department, all of the analysts, including myself.
All right, so you actually maintain the machine?
Yes, sir.
Okay. What mechanical experience do you have to be able to maintain a spectrogram, mass spectrogram?
I have been working with GCMS for about 4.5 years. The preventative maintenance shows that every time that we go inside the instrument, everything is changed out, cleaned, and replaced. Before doing any of the samples on the instrument, we do run an auto tune that tells us that the instrument is working completely fine. And we also run quality controls in front of our samples, our standards and our pre-negatives are ran before and after.
Is that machine inspected by any state agency?
A state agency such as,
Like DPS or anything come in and ensure the machine is working properly?
no, just the manufacturer. I believe it is Agilent who makes the GCMSs.
Okay, do you know when the last time they were in for a inspection of the machine?
No, I'm not sure, but I can get that answer to you.
Now, your work, is it reviewed by other technicians in the lab itself at a period of time? In other words, do you self-regulate or self-inspect each other's work to ensure that it's properly done?
Yeah, so our cases go through 2 different reviews. We have a tech review, and then we have an administration review, and the administration review is done by my supervisor,
And who's your supervisor?
Brian Cho.
And
Brian Cho, last name is CHO, the supervisor of drug identification.
And is that done on each test? And each test you perform is supervised by looked at by your supervisor.
Reviewed, yes, once the cases and the reports are generated, they are given to the technical reviewer. The reviewer then goes through the review process and then gives it back to us, and then we give it to our supervisor with service.
So you have nothing to do with the review process by the tech, right?
Not with my own cases, no, sir.
And then that is also reviewed then by the supervisor.
Yes, sir.
And how is it reviewed? Do you know? Is it just perfunctory looking at it and saying it looks good?
So the technical reviews that we conduct, we will go from beginning to end with their case record, their data, and the tests that they completed. In order for them to be able to release a report, the technical reviewer has to agree with everything that they did from beginning to end, including the presumptive test and the confirmatory test, excuse me, and also the results that it generated. So they have to accept what you did before you can release the data. Or agree.
What substances would also test as cocaine that is not cocaine?
I'm not sure I understand what you're asking.
There are substances out there that mirror the chemical composition of cocaine. They're not.
I'm not sure.
So you're not sure whether or not there could have been another chemical instead of cocaine that had the same chemical propensities?
From my knowledge, another substance that can mimic things like cocaine would be found out in the presumptive test that I did, whereas the color test, for example, lidocaine will yield a blue color as well as cocaine. However, when I did the GCMS test, the components of cocaine will fragment into a certain pattern. This pattern is kind of like a fingerprint. If it looks like cocaine, then it's going to match the fingerprint of cocaine. And that's what the spectrum does. We compare the fragments and ions and make sure that the fragments and ions pattern of the substance matches the fragments and ion pattern of cocaine.
Now, this was powdered cocaine or crack cocaine?
This was crack cocaine.
That's the witness.
Okay, let's do that.
All right, is this witness excused or subject to
She is.
re-school?
She's just excused.
All right, thank you.
This-
All right, state, call your next witness.
Your Honor, we have no further witnesses. We would offer State's Exhibit 76, which is a copy of the judgment that the defendant pled guilty to. No objection.
All right, then state's exhibit number 76 is admitted.
Representative.
Thank you. All right, state, do you rest?
Yes, Your Honor, State rest.
Defense rest, Your Honor.
State, do you close?
Yes, Your Honor.
Defense, do you close?
Close, Your Honor.
All right, the court will hear argument. State.
And Judge, a question for the court. I know that initially there were some video issues as far as what the court was able to see.
Yes. Well, my understanding is defense exhibit number 1 that they labeled, they never offered it into evidence. That's correct?
That is correct. We just use that to refresh your memory.
All right, so that's not into evidence. And for the record, the court is finding the enhancement true based upon your client's plea of true and also based upon state's exhibit number 76.
That is correct.
All right.
Okay. Your Honor, were you able to view State's Exhibit 1 when it was presented?
During the trial?
Yes, Your
Yes,
Honor. Okay.
but I had to look over my shoulder.
Yeah.
And I try to concentrate on witness plus the video behind me.
Bernie, do you have State's Exhibit 1?
Are you replaying state's exhibit 1?
Yes, Your Honor.
All right, if you could play it on the, if you will play it on the computer, then I can see it.
Yes, Judge.
Thank you. Brenna? Yes. Here's state's exhibit 76. Thank you. And Mr. Sanders, if you'll just do the share screen so that I can see.
Yes, Judge. And Your Honor, before I actually get into my argument, I want to highlight exhibit 1, specifically video 8 for the court again.
We will see if this works. Oh, just 1 moment. Just a second. Yes.
You won't have to publish.
No, I can see it on my screen since you're on the share screen.
Okay.
Yes.
On State Exhibit 1, this is video 8. Now showing, of course, Exhibit 1, video 2B. And this is Exhibit 1, video 4. Your Honor, the defendant, Mr. Williams, was convicted by a jury of 2 counts of aggravated assault.
Do you want to stop screen share?
Yes, sir.
Thank you, sure.
Your Honor, Mr. Williams was convicted of 2 counts of aggravated assault by the jury. I understand that they are assault by threat, and usually, I guess, people tend to see that as a lower offense, as opposed to bodily injury. On its own, it is a secondary felony, so the range would be 2 to 20. Looking at just count 2, which he was convicted of, the motor vehicle, I could see a situation where someone could try to rationalize his actions in that situation. He had just been punched by the victim. Victim was standing in front of his car. He could have backed up, but maybe he was still in the heat of the moment, and he drove forward. As you can see in the video, he still attempted twice to run the victim over, no matter how the victim tried to get out of the way. That case alone, I would probably say somewhere in the lower range would be appropriate. But we also have count 1 that he was convicted of, aggravated assault with a firearm. This is, in my opinion, the maximum. Like, this is the highest that it could be as far as an aggravated assault by threat. He goes into the building with at least 3 people, as you can see in the video, and fires off multiple rounds, 12 casings that they found. It was at best his intention to commit an aggravated assault by the injury. At worst, it was his intention to commit murder. And this could have easily been a capital murder. Like I said, there were 3 people inside. He then fired 2 rounds outside of the vehicle. Who knows where those rounds could have gone? Or sorry, outside of the store, who knows where those rounds could have gone? It could have hit anyone. His actions were egregious, and if this were just a second-degree felony, we would be asking for 20. However, he's pled true to the enhancement paragraph, which bumps us up to a first-degree range. We're looking at 5 to 99. So we'd ask the court to consider what his prior felony was and the punishment that he received. If he was convicted of murder, as you can see, he pled not guilty and went to trial. The jury found him guilty of murder, and he was sentenced to 30 years in 1997. Doing the math, that means he's still on parole for 5 years. He's been out, I'm not sure exactly when he got out, but he's out on parole and he's still committing offenses. In punishment, we proved up that he also possessed drugs, crack cocaine in an amount of 4 to 200. And so, Judge, I guess our argument is that Mr. Williams has shown that he has no regard for human life. He's committed a prior murder in the past. He gets out while on parole and he tries to commit another one. We are asking for the maximum life on this case, Judge.
All right. Defense, it's the court's understanding that you are not requesting a pre-sentence investigation. Is that correct?
That is correct, Your Honor.
All right. And State, do you have any objections to proceeding without a pre-sentence investigation?
No objection, Your Honor.
All right,
Judge.
All right. So the State will hear your argument, defense.
May it please the court.
Oh, and Mr. Chirek, you can remain seated.
Oh,
I don't.
remain seated.
Yes, I don't take that as a sign
I'm
of
old
disrespect.
school.
I understand. I don't take it as a sign of disrespect. It's just easier for the microphones to pick up and for Brenna to hear.
Got you, I'd like to address some of the points. Judge, with regard to the prior murder conviction, that the court will look at the record of that. He was not the shooter. He was actually indicted as a party because he was at the scene.
Your Honor, I'm gonna check the facts, not any evidence.
Just a moment. Could I see State's Exhibit number 76, I believe? Thank you. I'm so sorry, Brenna. Just a moment. Let me do this again, and then I will on State's objection. All right, Mr. Chair, it appears that the indictment states that Mr. Williams, according to the indictment in State's Exhibit number 76, it stated that Mr. Williams shot at the complainant. That's what's in the indictment.
Yeah, because the indictment's going to say that basically because they don't allege party, they just allege the violation in the indictment.
Well, I'm going to sustain the state's objections because according to State's Exhibit number 76, the argument that you're presenting, it is not on the face of State's Exhibit number 76.
Okay.
Mr. Church, would you like to review State's Exhibit number 76 to show
I-
to
I've got
Mr.
it in front of
Williams?
me, Judge.
All right.
Okay, in addition, Judge, basically with regard to the drugs, I believe that they were found based upon an illegal search. I was clearly, Detective Trevino said that they followed him before they ran the license plate. And then when they were actually stopped, ran the license plate to determine that the sticker had expired. So we believe that any drugs found would have been the fruit of an illegal search and therefore should not be considered by the court. We'd ask the court to use their judgment and years of experience in sentencing the defendant in this case.
All right. And no evidence was presented to the court on this point, but how old is your client, Mr. Turek?
Pardon, Judge,
How old is your client?
how old are you? 41? She's 41, Your Honor.
All right, state argument.
Judge,
Any rebuttal?
I would just point out that, and I can't remember if I said it initially, but he was sentenced to 30 years and that hasn't prevented him from committing new offenses. And so we would have, if you aren't gonna sentence him to life, that it would be higher than the 30 years.
He was a kid at that time.
Excuse me, who's waving from the back of the courtroom? From that door? The person who's in that shirt, who is that?
Have a seat, sir. Are you gonna come in? Have a seat. And just wait.
Thank you.
Your Honor, my
Yes.
client is insisting that he address the court.
Well, both the state and the defense have rested and closed, Mr. Turek.
I agree, Judge.
All right. I mean, if the state has no objections, but then Mr. Williams, that would subject you to cross-examination. Do you want to speak to your client?
I've already advised him, Judge, that if he speaks, the state can question him.
Did either party want to speak to count 4?
That's the one that's got the joinder, right, Judge?
Yes.
So that would be an issue because we do not know what the jury determined which party was potentially subject to the deadly conduct. And since they found him on the aggravated assault, there would be an issue of the election on that particular case because the elements would be clearly the same. So we don't know whether, they found for deadly conduct against Williams and Muhammad, or Muhammad alone, or Williams alone. So I think, Judge, that's an issue with the finding on that. It's inconclusive.
Judge, our concern is, I mean, it's a lower offense, even with the enhancement, it's the second degree, and so I'm not sure how the court would like to proceed, but we would have no objection to, I guess, whatever is appropriate.
All right. Are you requesting that count 4 be set aside? State and defense, are you objecting if the state is requesting such?
No, if they're requesting count 4 be set aside, I have no objection.
Yes, Judge, that is our request.
All right, then count 4 will be set aside. And then that leaves count 1 and 2. On count 1, court will sentence you to 40 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. In count 2, the court will sentence you to 40 years in prison. Give you credit for any time served, and there's an affirmative finding of deadly weapon. Just one moment. And the court will note that both parties agreed to set aside count 4. And counts 1 and 3 will run concurrently.
1 and 2. Your
I'm
Honor.
sorry, 1 and 2. Thank you. Is there any restitution?
Not that we're aware of.
Is there anything else from either side with regards to sentencing? State,
Nothing from the state.
defense?
Nothing to defense, Your Honor.
You have your hand raised, Mr. Williams?
Yes, Your Honor, may I speak?
No. If it is about this case, no, the court has passed its sentence.
Yeah, but
my
my
rights
rights been violated in this courtroom.
Mr. Excuse me. Did you review trial court certification with your attorney? Did you understand it?
Yeah, you found me guilty without a victim.
All right, because,
That's
all
violating the constitutional right to my Sixth Amendment.
right, Mr. Williams, first, number one, you need to lower your voice. Number two, I did not find you guilty.
Yeah,
A
the
jury
did.
found you
They don't know
guilty.
the law. You know the law.
No.
You should uphold the constitutional right.
All right, so is there any
Nothing.
victim impact?
No, Your Honor.
All right. All right, then, you can be removed. Your Honor.
Advised me he wishes to appeal. I will file a notice of appeal today, but he'll need a new attorney appointed for the appeal.
Yes,
That's what's wrong.
all right, and Mr. Chirac,
Hey, you play dirty games, man. You know that's
Excuse me.
some punches you pull, man.
Mr. Williams,
Yeah.
Mr. Williams, stop.
Bitch, man. You
Bye.
married to another man.
Bye.
That's what you is. You married to
Excuse
another
me.
man, homosexual. Get them all, don't I?
Mr. Chirac, could you do me a favor? I don't see his trial court certification.
I did sign it, did I?
Yes. I put it with the new second.
Okay, we will see. All right, and I'll give you a copy of this, Mr. Chirac.
3 years dealing with that guy.
Oh, just 1 second. Let me. And we start back up at 11, correct?
Yes.
All right, court then will resume, everyone, court will resume at 11 a.m. So just make sure that you're back here at 11 a.m. You can go downstairs and get some breakfast if you would like, but just make sure you're back in court by 11, okay? Yes. Yes, he can go downstairs to the cafeteria, but don't leave the courthouse because GPS will show that he's left the courthouse. Are you his mom?
Yes, ma'am.
Oh, I know you will not let him violate anything.